As part of our commitment to giving you all sides of the really important issues this election, Denver 7's Jennifer Kovaleski is exploring another viewpoint on Amendment 74. That's the one that deals with proposed changes to the Constitution to add property rights protections. And tonight, Jennifer is looking at the potential lessons learned from other states.
Let's start with a quick overview. A yes vote on Amendment 74 adds these 11 words to our state constitution, giving you the right to sue the government if a government decision reduces your property value, even by, say, 10%. Right now, you can really only get compensation in eminent domain cases, or if you lose up to 90% of your property value. That's what the Colorado Farm Bureau says they are trying to change.
We want to level that playing field and give them the equal rights that the government has.
That's what 74 does. It protects the property rights of all, including yours.
But critics argue the amendment is way too broad. They go so far as to call it Tabor 2.0, saying it could bankrupt some Colorado towns and would be a disaster for taxpayers.
Just about any local government decision could well be implicated with a lawsuit under this language.
More than 100 elected city leaders, along with Sam Mamet with the Colorado Municipal League, have come out against 74.
It may be the single worst measure I've ever seen on the ballot.
Now that you have the basics of each side's argument, let's bring in another perspective we didn't talk about in our original 360. A handful of states have considered ballot measures opponents say are similar to Colorado's Amendment 74. For our purposes, let's zoom in on two states in particular, Washington and Oregon. Voters in Washington rejected their property rights measure after a study there showed it would cost taxpayers nearly $8 billion to pay compensation claims, while Oregon passed Measure 37 in 2004. It gave landowners the right to seek compensation if a city's land use regulation reduced their property's value. What happened next, opponents say, is a case study for why Colorado's amendment is a bad idea.
There were several $1 billion worth of claims filed against both the state of Oregon as well as local governments in Oregon.
We checked, and this study from the state of Oregon says after the measure passed, the total amount of claims filed against the state exceeded more than $17 billion, which led to voters repealing most of Measure 37 3 years later.
It got totally out of hand.
This is about protecting all Coloradans.
The Colorado Farm Bureau sees this issue very differently. They believe the Oregon measure is an example of why the Colorado approach is better policy, because it works with Colorado's existing constitutional protections and legal framework. In other words, Oregon's measure gave governments only 180 days to respond to claims or fork over the cash, with no clear standard for the burden of proof. Under Amendment 74, they say the burden of proof remains with the property owner, while opponents still say Oregon's mess is a clear example of what could happen in Colorado if voters pass Amendment 74, and they question the campaign's real motives.
You've got deep pockets, you can do what you want.
What you just heard Mamet say is referring to the real money behind this campaign. The state's largest oil and gas companies are shelling out millions for advertising in favor of 74. They see it as a way to hedge their bet against Prop 112. We have much more on that part of this story online right now. Shannon?
Thank you, Jennifer. Very helpful there. And remember, you can watch all of our 360 political coverage on Colorado issues right now on the Denver 7 app and on Denver 7's channel on Roku.